Welcome to the deep dive. Today, we're unlocking a really powerful and honestly often surprising idea in contract law, the statute of frauds. Specifically, how the UCC, that's the Uniform Commercial Code, makes your silence legally binding.
Exactly. It sounds counterintuitive.
Totally. Our mission is to get under the hood of UCC Section 221.2, the between merchants exception. We want to see why just, not sending a simple letter could end up costing you a fortune.
Yeah, and this is a fascinating deep dive because it really highlights that tension between old traditions and modern business needs. The statute of frauds historically was all about stopping people from lying about handshake deals.
Right, demanding proof.
But today, business moves fast. Deals happen on calls, emails. So the UCC created this, pretty aggressive rule. It forces quick risk allocation between professionals. It changes the game for how deals get confirmed.
We're using a case to see how this plays out.
We are. The classic Hay contract case, Azevedo v. Minister. It's perfect for modeling exactly how this deadline, this 10-day clock, actually works in practice.
Okay, sounds good. Let's start with the basics then. What's the foundational rule under the UCC for contracts selling goods? When do you absolutely need something in writing?
So the baseline, the general rule, is in UCC 2201 subsection 1. And it says any contract for selling goods where the price is $500 or more generally needs some kind of sufficient writing to be enforceable.
$500, that's the magic number.
Yep, $499. Oral deal's fine. Cross that $500 line and you really need some paper trail or an exception.
And what counts as sufficient? Does it have to be this formal document, like with lawyers involved? Does it need the price, delivery details, all that?
Surprisingly, no. It's pretty minimal, actually. The writing just needs three basic things. First, it just has to indicate that, a real contract for sale was made between the parties.
Okay, just evidence of a deal.
Second, it needs to be signed. But crucially, signed by the person who's trying to get out of the deal. The one you're trying to enforce it against.
The defendant, essentially.
Exactly. And third, and this is key, it must specify a quantity. That's the one term the UCC is really strict about. You can leave out price, delivery, whatever, the court can fill those gaps, but quantity. Gotta have it. And the contract's only good up to that stated amount.
Okay, that general rule seems pretty rigid. But you mentioned exceptions. The UCC created this big one for people who trade regularly, right? The between merchants exception in 2001.
Yeah.
Before we get into the rule itself, why was it needed? What problem did it fix?
It fixed a really unfair situation, a sort of strategic loophole. Think about it. Two merchants make an oral deal. Merchant A immediately sends a confirmation letter.
Okay, doing the right thing.
Right. But under the old rules, that letter only bound Merchant A because they signed it. Merchant B, the recipient, not bound. So Merchant B could just sit back and play the market.
Ah, I see.
Yeah. If the price of the goods went up, B could say, great, we have a deal, and enforce it against A. But if the price dropped, B could just tear up a letter and say, nope, statute of frauds, no signed writing from me.
That sounds like a huge risk for the person who confirms the deal promptly. So how did the UCC fix that specific problem? How does it force both sides to commit?
It basically weaponized silence. That's the core idea. The merchant's exception says, look, if one merchant sends a proper confirmation, the other merchant can't just ignore it. They have to object in writing and fast.
Okay, state the rule for us. What does 22012 actually say?
All right, the black letter rule is this. Between merchants, if a writing in confirmation of the contract and sufficient against the sender is received within a reasonable time, and the party receiving it has reason to know its contents, it satisfies the requirements of a writing against such party unless written notice of objection to its contents is given within 10 days after it is received.
10 days. That's the crucial window.
10 calendar days. Miss it, and your silence can lock you into the deal described in that confirmation, even if you never signed a thing.
Now, you keep saying between merchants. We should probably clarify that. For listeners maybe running their own business, how broad is that term? Is it just massive corporations, or does it cover smaller players, like, say, the rancher and the hay buyer in our case?
Oh, it's broad, very broad. A merchant under the UCC isn't just some giant company. It's basically anyone who deals in the type of goods involved in the contract.
To a professional in that field.
Exactly. Or even someone who just holds themselves out as having special knowledge or skill related to the goods or the business practices involved. So yes, if you regularly run a ranch and sell hay, you're a merchant. If you regularly buy hay for your ranch, you're also a merchant. And this aggressive 10-day rule, it applies to you.
So the law basically expects professionals to communicate quickly and clearly. Let's dive into Azevedo v. Minister then and see how this played out. First, Lay out the key facts for us. What happened here?
Okay, so we have Azevedo. He's a rancher, the buyer, and Minister, who runs another ranch, he's the seller. Back in November 1967, they make an oral agreement. Azevedo's going to buy hay from Minister. They agree on prices, like $26.50 per ton for some, $28 for other types.
So an oral deal.
Yep. And Azevedo shows he's serious. He puts $20,000 into an escrow account right away and actually starts hauling some of the hay. But here's the rub. They later disagreed on the total quantity. Minister said 1,500 tons. Azevedo said, we never agreed on a specific amount.
Okay, classic quantity dispute and the confirmation part.
Right. Minister starts sending Azevedo these periodic account statements. But the really crucial one, the one the case hinges on, doesn't arrive until January 21st, 1968. That's about 10 weeks after their original phone call.
10 weeks later.
Okay.
And what was the core legal issue the court had to decide?
It was really two questions rolled into one. First, was Minister's accounting statement good enough to count as a confirmation under that merchant's exception rule 22012? Did it meet the minimum requirement?
And second,
Even if it was a confirmation, was sending it 10 weeks later still within a reasonable time? Because if it wasn't sent reasonably quickly, then the exception wouldn't apply, and Azevedo could use the statute of frauds to block enforcement.
got it. So what rule of law did the court apply here? Give us the specific rule, the Nevada statute, and break it down into the elements they had to check off.
Sure. The court applied Nevada's version of UCC 2201, which is NRS 104.22012. To see if it applied, we can break that merchant's exception down into, let's say, 7 key elements. You got to satisfy all 7 for the oral deal to stick against the person who didn't sign.
Okay, list them out first.
1, both parties have to be merchants. 2, there has to be a writing that is in confirmation of the contract. 3, that writing also has to be sufficient against the sender, meaning it binds the person who sent it.
Which usually means signed by them and has a quantity.
Well, exactly. Which leads to 4, the writing must specify a quantity. 5, the writing must actually be received, and the recipient has to have reason to know what's in it. 6, crucially, it must be sent within a reasonable time. And 7, the recipient must fail to give written notice of objection within those 10 days after getting it.
Okay, a 7-part test. Thanks. Now let's get into the court's elemental analysis, step by step. They agreed they were merchants, right?
Okay.
And Azevedo got the memo, knew what it said. So let's get to the contested stuff. How did the court handle the second element? Was that January accounting actually in confirmation of the contract?
Right, this was a key fight. The court said yes, it was. Azevedo argued it wasn't explicit enough, didn't mention the November deal. But the court looked at the language in the memo. It said something like, approximately 16,600 bales of hay yet to be hauled on your purchase.
Your purchase. That phrasing seems important.
Very. The court basically adopted a pretty liberal standard here, quoting the UCC comments. It said, all that's required is that the writing gives a basis for believing the oral evidence rests on a real transaction. That phrase, your purchase, strongly suggested a pre-existing deal, not just, an offer or ongoing negotiation. So element 2, check.
Understood. Now, element 4, quantity. We know the UCC is super strict on this. Mizers claimed 1,500 tons orally, but the memo mentioned bales. Did the court find a specific enough quantity in that January memo?
Yes, it did. That phrase, approximately 16,600 bales of hay, was specific enough for the court. They acknowledged it was an approximation, but the UCC allows that. It stated a clear quantity.
And importantly, that quantity then becomes the ceiling.
Precisely. The contract could only be enforced up to those 16,600 bales mentioned in the writing. It satisfied the quantity requirement, element 4. Check.
Okay, now for maybe the trickiest part, the most debated element. Number 6. Was that memo sent within a reasonable time? 10 weeks feels like a long time, especially for something like hay where prices might fluctuate. How did the court justify that delay?
Yeah, this is where you really have to look at the context, not just the calendar. The rule for reasonable time under the UCC explicitly says it depends on the nature, purpose, and circumstances of the situation. It's a question of fact.
So what were the specific circumstances here?
The court highlighted why Minister sent the memo when he did. It wasn't just out of the blue. He sent it because Azevedo's initial $20,000 deposit was nearly gone. The memo wasn't just confirming terms. It was basically a warning saying, hey, you've used up your credit on this purchase. You need to pay more if you want to keep hauling.
So the timing was linked to the performance of the contract itself.
Exactly. The court saw the timing as reasonable for the purpose of managing that ongoing transaction and the payment schedule. It wasn't just about confirming the original deal weeks later.
And did Azevedo's reaction matter here?
Hugely. This was critical. What did Azevedo do when he got this memo warning him his deposit was low based on his purchase? He didn't write back objecting to the existence of the purchase or the quantity. Instead, he deposited another $3,000 and kept hauling hay.
Wow, so his actions basically confirmed the timing was okay for their ongoing business.
That's how the court saw it. His performance after receiving the memo strongly suggested the timing wasn't unreasonable within their specific relationship and the context of the deal. So, element 6, reasonable time. Check.
Okay, that leaves element 7. Did the recipient, Azevedo, object within 10 days of getting that January 21st memo?
Nope. He failed to object. And remember, the statute demands a written notice of objection specifically to the contents of the confirmation. Silence isn't enough if you want to preserve your defense.
He didn't send a letter, didn't send a telegram?
Nothing. He didn't challenge the January 21st accounting nor subsequent one in February. His silence on the terms, combined with his actions depositing more money, hauling more hay, was fatal to his statute of frauds defense. Element 7. Check.
So they walked through all the elements, and since all were met, what was the court's final conclusion?
The court concluded that the oral agreement for the hay, up to the quantity mentioned in the memo, was enforceable against Azevedo. Minister's accounting satisfied all the requirements of the merchant's exception, UCC 2201. Azevedo's failure to object in writing within 10 days meant he lost his statute of frauds defense.
That case really drives home how powerful that exception is. To make that 10-day rule even more concrete, let's try a hypothetical. Let's say you, our expert, you run a big organic farm. You're a merchant.
Okay.
You verbally agree over the phone to sell 100 crates of some unique heirloom tomatoes to a fancy restaurant chain owner, also a merchant. You agree on $50 per crate. The next day, you get an email confirmation from the restaurant buyer. Looks good.
Yep.
Except they wrote $15 per crate instead of $50.
Ouch. 15 instead of 50.
Yeah. What do you absolutely have to do, and how fast?
Okay. Under UCC 222012, I must send a written notice of objection specifically about that price term within 10 days of receiving that email.
What if you just call them or email back saying, hey, let's talk about the price?
Not good enough. A phone call isn't written objection. An email just wanting to talk might not count as objecting to the contents, specifically the wrong price. To be safe, I need to send something. Written email is fine, but it should clearly state, I object to the price term of $15 in your confirmation dated XYZ. The agreed price was $50.
And if you don't send that clear written objection within 10 days,
Then, assuming their email confirmation was otherwise okay, like it confirmed the quantity of 100 crates and showed it came from them, I'm stuck. I would be legally obligated to sell those priced tomatoes for $15 a crate. My silence binds me to their incorrect term.
wow, that really shows the bite of 2220. You snooze, you lose.
You really do. It forces merchants to read their mail and act fast.
Now, the Azevedo court also mentioned another way the contract might have been partly enforceable, even if the memo had failed. That's the performance exception, right? Under UCC 22013, how does that one work?
Right. That's kind of a safety net based on fairness. It prevents one side from, accepting goods or payment and then trying to wiggle out of the whole deal using the statute of frauds. Subsection 3C says a contract is enforceable even without a proper writing, but only with respect to goods for which payment has been made and accepted or which have been received and accepted.
So it's about what's actually happened, not the whole promise.
Exactly. In Azevedo, think about that $20,000 Azevedo initially paid and the hay he hauled using that money. Even if the court had found the January memo defective, maybe the timing was unreasonable, the contract would still have been enforceable for the amount of hay covered by that $20,000 payment that minister accepted, and for the hay Azevedo actually received and accepted.
So it salvages the executed part of the deal.
Correct. It enforces the actual performance. That's the big difference. 22012. The merchant's exception, if it applies, can make the entire oral contract enforceable up to the quantity in the confirmation, thanks to silence. But 2201C, part performance, only enforces the specific part of the contract that has already been performed through payment or acceptance of goods.
That distinction is crucial. One validates the whole promise via silence. The other validates only the actions already taken.
Precisely. Okay, so putting this all together, especially for someone facing, say, an exam question on this, here's a quick diagnostic checklist. How to spot and analyze the statute of frauds issues under UCC Article 2.
Perfect. Let's hear it.
All right. Step 1, threshold check. Is this even covered? Is it a contract for the sale of goods? And is the price $500 or more? If the answer to either is no, then UCC 2201 doesn't apply. Your oral deal is likely fine. If yes to both, you need a writing or an exception.
Okay, first hurdle.
Step 2. General writing check. 2201. Is there any writing signed by the party you're trying to sue, the defendant? Does it indicate a contract and state a quantity? If yes, great, it's enforceable up to that quantity. If no signed writing from the defendant, move to the exceptions.
Makes sense.
Step 3. Merchant's exception diagnostic, 2201, this is the big one we focused on. Ask these 4 sub-questions. First, are both parties merchants? Second, did one merchant send a confirming writing soon after the oral deal? And was it sufficient against the sender signed by them? Stated quantity. Third, was it sent within a reasonable time given the circumstances? Fourth, did the recipient fail to object in writing within 10 days of getting it? If you can answer yes to all 4 of those, bingo. The oral contract is fully enforceable against the recipient, even without their signature.
The silence trap.
Exactly. Then, step 4, performance diagnostic 22013. If you struck out on the writing exceptions, check for part performance. Can the contract be enforced at least partially based on goods that the buyer received and accepted, enforceable for that amount, or payment that the seller accepted, enforceable for the quantity paid for?
So a clear step-by-step process.
Yep.
Threshold, general writing, merchant's exception, then part performance.
That's the analytical flow and helps you hit all the key points systematically.
This whole deep dive really shows, in the world of commerce, silence isn't just awkward, it can be incredibly expensive.
Yeah.
You might think you can just ignore some email or memo, but under the UCC, that silence can be legally interpreted as agreement. It makes an unsigned oral deal binding.
It absolutely does. It imposes this duty on merchants to be vigilant, to read their communications carefully, and to respond quickly if something's wrong. But it does raise one last interesting policy question, doesn't it? Even with this powerful merchant's exception making it easier to enforce oral deals, why is the UCC still so incredibly strict about that quantity term? Remember, the memo in Azevedo had to state a quantity. Why couldn't the court just fill in the 1,500 tons Minister claimed if they believed a deal existed? Why is quantity the one term that must be in the writing, no exceptions?
That's a great point. Even when silence confirms the deal exists, the scope is limited by what's written down about quantity. That's the final thought for you, the listener, to maybe mull over. What fundamental policy is the UCC serving by making quantity the one non-negotiable, non-fillable term in the statute of frauds analysis, even between merchants? Why that specific term?